This past weekend could have rewritten the very definition of who is an American. Instead, a series of court decisions has preserved a 150-year-old rule, at least for now. Here's how President Donald Trump's bid to end birthright citizenship ran aground.
On his first day back in office, Trump signed an executive order instructing federal agencies to deny U.S. citizenship to children born in the United States if their mother is undocumented or on a temporary visa and their father is neither a citizen nor a green card holder. That order confronts the 14th Amendment head-on. Ratified in 1868, its citizenship clause says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." For more than a century, courts have read that language to grant automatic citizenship to nearly everyone born on U.S. soil. The administration argues that the key phrase, "subject to the jurisdiction thereof," has been misread and does not cover the children of non-citizens. Civil rights groups, immigrant advocates, and 22 states counter that the Constitution can't be rewritten by executive fiat. They call the order a flagrantly unlawful attempt to strip citizenship from newborns. The legal fight has ping-ponged through the courts. In late June, the Supreme Court weighed in not on the merits of the order, but on how lower courts may block it. In a case called Trump v. Casa, the justices limited the use of nationwide injunctions, ruling that lower courts should generally shield only the plaintiffs before them. They did, however, leave two escape hatches. Broader injunctions are permissible in class action suits or when a narrower order would fail to give complete relief. Opponents wasted no time. Within days, a federal judge in New Hampshire certified a nationwide class of all babies who would be affected, extending protection far beyond the original plaintiffs. Next, the Ninth Circuit Court of Appeals declared the order unconstitutional because it contradicts the plain language of the 14th Amendment. And just this past Friday, a federal judge in Boston reinstated a nationwide block, concluding it was the only way to protect the 22 states that had sued. Anything less, the judge said, would create a patchwork of rules, breeding confusion for families and chaos for federal programs. The result? The executive order remains frozen coast to coast. The White House vows to appeal, and many legal scholars believe the core question, can a president limit birthright citizenship without amending the Constitution, will soon be back before the Supreme Court. For now, though, the 14th Amendment stands unchanged, and every child born on U.S. soil continues to start life with the same promise of citizenship that has defined the nation since Reconstruction.